Welcome everyone to this webinar episode from the PrivacyRules Alliance. Today with me, I have three experts that will support us in understanding how the PrivacyRules Alliance can support company in dealing with one of the most discussed framework of the moment, which is NIS2, together with other frameworks that are often connected or related to it. What we will do will be going through a case scenario and see how each of our experts from the legal to the cybersecurity standpoint can support companies that are in need of legal and cybersecurity assistance. We will do that with the three guests of the day, which are all members of the PrivacyRules Alliance. First of all, we have Charlotte Riley, Director of Information Security at CSS Assure. We also have with us Endre Varady from the law firm VJT Partners. And last but not least, we have Michaela Holíková from Rowan Legal, where she's an associate and she supports in the privacy, data protection, and cybersecurity related matters. So first of all, thank you all for being with us today and for supporting actively PrivacyRules. It's great to have experts like you together with us. And okay, let me immediately start on what we wanted to discuss today, which is indeed how to deal with NIS2. In order to do that, we have created a fictional scenario that is based on a company, which is a company working with health data, and that is headquartered in Hungary. That's why we have Endre from Hungary with us today. But this company also has system hosted across the EU and in particular in several countries, including Czech Republic. And that's why we have Michaela with us today. And it offers diagnostic tools to hospital and use cloud infrastructure and third-party processors, which is why we also need cybersecurity experts like Charlotte, which is with us again today. So once we have this brief overview on which is the situation, I believe that first thing to do would be to setting a bit the ground, and I would like to do that starting with the Hungarian picture. So Endre, according to my description, is MedOptix, this is the name of the company that we have created, of course it's fictional. Is this company clearly in scope for NIS2 according to Hungary? And what are the mistakes that you normally see business making when working through the Hungarian thresholds?
Sure. Well, from activity perspective, MedOptix is clearly under NIS2 scope. First of all, directly as a cloud service provider, and also indirectly as a supplier in the healthcare sector. And we have to see that at the same time, this is more than just checking an activity list from NIS2 directive. On one hand, because we have financial threshold as well. So in case of MedOptix, this is either employing 50 employees or reaching an annual revenue of 10 million euro. And what is the problem here that businesses apply these applicability requirements too rigidly, and they often fall under common business pitfalls. For example, they think that if they reduce the employee staff to 49 from 50, then they could immediately escape from NIS2. Well, unfortunately, that is not the case. And it is also a common misconception that they think that the individual company size matters, not the group company size, when in reality the vice versa applies. So all this shows that even already at the applicability phase, businesses can make serious mistakes with incorrect legal interpretations.
Perfect. Thanks a lot, Endre. And this gives us already, a starting point under the legal part, and we can say that the legal scope is identified. Then whenever this is done, one of the key problems is translating this into system level actions, which brings me to my next question to Charlotte, which is how do you normally help clients like MedOptix figure out where they have to focus their efforts to be, let's say, more effective in translating these.
Thanks, Alessandro. Well, as Andre has mentioned, this is quite complex in terms of scoping, and then we have to think about translating the implications of that scope into something that's operational and that we're able to implement. So we have to remember, of course, that this is a regulatory compliance, and we need to understand what the requirements of that is. And that's where that bridge between the legal and the technical come together. So for a technical person to understand what is required for me to be compliant. To do that, the NIS2 Directive and the Hungarian implementation of the NIS2 Directive in the Cybersecurity Act is asking that we do a risk assessment. From there, once we understand a risk as has been driven by the requirements, we then have to do a gap analysis and understand what kind of controls we need to put in place for those systems in order to pass an audit and be in the place that a company wants to be. So this can be also complicated if there are systems that then live in different countries and therefore have a different, we'll say, nuance to controls that have to be in place. So what we do to help is translate okay, we know we need to do something. What does that actually mean? How do we approach a risk assessment on systems? How do we then create a roadmap? How do we remediate against gaps that have been created? And we've created a system that allows both the legal teams and the technical teams to collaborate, to be able to see progress, to see where risks exist, prioritized remediation plans that are obviously driven by things like audits, upcoming audits, timeframes. So something that's actionable, understandable by all. And at the end of the day, a technical, as I've just said, the technical implementation has to meet that legal requirement. So then having that signed off by the legal teams as well.
Thank you very much for making this part more clear and let us understanding how do you or would you support companies of this kind in a situation like this one. I have a question now for Michaela that is not in this panel by case, meaning that we also wanted to give an overview to our listeners that is not just related to in general how to comply with NIS2, but also in different type of situations. So we know that Hungary, for example, it's a pretty advanced stage in terms of NIS2 implementation, but in Czech Republic is not the same, meaning that the legislation is not final yet. So Michaela, we would be very interested to learn how should companies be doing now, what should they do now to avoid being not compliant later or find themselves not ready for a framework like the NIS2 one that is pretty complex.
Right. Yeah. Thank you. Thank you for the question. It's right that in Czech Republic we haven't finalized the legislation process as well in Germany, but on the other hand, I would say we are on there is a bigger progress than in Germany. So. Yeah, I would say what's important within this too is that it's already a topic like for 2 years, maybe 3 years. So usually in every country, let's stay at the Czech Republic, it's that we know the proposals. So it's always good to know the proposals and do some kind of preliminary, or maybe we don't have to call it preliminary. We just should do the the impact assessment to have the primary view on the fact if the NIS2 or if the local implementation will have some impact on my business. I like actually very much our scenario, because what we can demonstrate here very well is that there always can be some kind of joint effort across the company, and this is something what I would really recommend to talk to each other and to really be in close contact. Of course, the criteria for the regulated services, they varies across the countries in the European Union, but maybe this is the reason why it's even more important to communicate and do this kind of impact analysis in every state, and at the end maybe put everything together to really have the overview of what kind of steps has to be done in the future. So yeah, to come to some conclusion, it's not about, or I would say the approach, the final legislation is not here, so we don't have to do anything. It's like generally wrong, because drafts are already known in all the European countries, I would say, and that's actually maybe one of the reasons why are we here today, to really provide a view on that the effort can be joined and a lot of things can be already done, not to be done and not prepared in the future.
Yeah, and I think this also goes beyond simple interest in being compliant, meaning that we are really speaking about security of information within a company, which should be of a higher interest other than, and this brings me to the next point, the fact that many companies operate abroad or in different countries, adding an additional layer of complexity to framework like the one of NIS2, in particular if there is divergence both in terms of interpretation of the framework and also application of it specifically. Which brings me back to Endre and to the Hungarian interpretation, which has been defined as a owner-based interpretation of the framework, from which we understand that even system hosted abroad might still be in scope under the Hungarian law. So, Endre, how does this affect companies like MedOptix and in particular having, as we were describing at the beginning, also infrastructures in countries like Czech Republic as well as Germany?
Yes, the owner-based interpretation is a very critical one, and we have to understand it to see the big picture. And this means that even if some infrastructures are in Germany or Czechia, if these systems are owned and controlled by the Hungarian entity, then those infrastructure could still fall under Hungarian NIS2 obligations. And this could create tricky situations, because maybe Germany and Czechia have some different compliance rules to the same infrastructure. So this is why cross-border coordination between legal and cyber security experts is absolutely essential. Especially in case of such a cross-border company. And the best thing is to think about some international cyber security standards like ISO 27001 or NIS2 853, because there are many common grounds, and if we start with an international cyber security strong framework, then we can streamline our processes.
Perfect, Endre. Thanks a lot for that, which it's a clear, interesting point also for sharing the another point that we will probably touch upon later on, meaning the use of other standards, for example, that can often help in being compliant, or a step closer to compliance with many frameworks. But I think this one of operating across multiple jurisdictions is it's really a key point related to NIS2. So I would like also to have the point of Michaela on this. How do you support companies and let's say advise them when it is about overlapping or even conflicts between the requirements, even of the same framework in this case?
Yeah, it's actually a great question again, because as I heard Endre, I felt like, okay, it's good, it's ownership. But if I'm not mistaken, there are like additional criteria in the NIS2. For example, when there is incident reporting, and the most common question is like, to which authority should we then report the incident? Is the Hungarian one, or the Czech one, or the German one, or what? And I believe that there are some like additional criteria that says that it depends actually on the country or on the branch, let's say, which really has the ownership, like the material ownership of the system. So for example, if we would like work more on our scenario, and we would say that in Czech Republic there is the security department, which is actually providing the SOC and all the like security services, I would say that then this kind of like the Czech branch has the most the biggest impact to this like real cybersecurity or doing the cybersecurity within the company. And then probably the Czech Institute, the Czech Cybersecurity Agency would be the one to whom it should be reported, even if this incident would occur in Hungary, probably. But I would say, this is like super important, not important also, but I wanted to say interesting to really see how this will be applied in the future. Because as you can feel already, there are some like different points of view. And I think partially it will depend on the decision making of the authorities, maybe even the European courts to really get this right in the future. Because now sometimes it's really like it goes against each other. Last remark, maybe say on the other hand, not to really overcomplicate it. I think the most important part at the end will be to really have the streamlined processes within the company, like our MedOptima or Med something, because at the end it's not really so much important to which authority the incident will be notified, but that it will be notified according to some process, so the company can really demonstrate that the NIS2 was handled properly, the process is in place, and there is a certain system to fulfill all the obligations.
Clear. Thanks a lot also for those, practical tips. And I think, one of the key points also in this type of situation is trying to identify like a unique point of contact, or try to centralize the work in order to make sure that it's streamlined in the right way, which brings me also to Charlotte's, meaning that from the operational point of view, Charlotte, how do you support companies in building a single compliance framework, in particular that when these have to respect different national applications of that framework?
So we work with clients to create a core compliance framework that is anchored to the NIS2 requirement, but also has the flexibility to build in the nuance of the national requirement. So to Michaela's point, that the company has to build something that works holistically, but also based on the legal input and the scoping is able to identify specifics depending on where systems exist and those requirements. So we've talked about with Endre that a Hungarian system, for example, might not be hosted in Hungary, but it's hosting Hungarian data, and therefore it's in scope for the Hungarian requirement. Well, that same system, I suppose, if it was in Germany or another country, could still be in scope for those specific country requirements. So the main thing, and it's the same with any compliance regime, is the understanding. So once you've got that understanding piece, you then need a really robust management solution. And that's what we do. We create something that's flexible, understandable, and it's creating that action plan where you can both action it and record it, audit it, and repeat, because this is an ongoing living, breathing thing that that is essentially there as to drive system level appropriate cybersecurity controls. So it's been designed in this way, so companies are doing the appropriate thing, but of course it has to be manageable. And I think we'll get into it a little bit more in the next set of questions, but having existing technical frameworks in place that can be mapped, those controls can be mapped like ISO 27001 to say, look, you know what, we've got round numbers, we've got these 10 systems, we have these controls in place already on them. How do those stand up to the NIS2 requirement and the country specifics? And that might eradicate some of the work that already needs to be done, and then you're left with the delta of making sure you meet those technical specifications.
Perfect, Charlotte. Thanks also for your contribution in these, and I believe that these last or second round of question clarified the issues and the difficulties of dealing with multi-jurisdictional type of situation. And I think it was clear the value of having a team of people that know each other, that can constantly communicate in order to make sure to support the client based on the nuances of the different regulation and frameworks. And it's great to have someone on the backside, in particular for what concerns the management of the activities that can support, that might be, the privacy rules team as well as Charlotte, which brings me to the other point, which is very much connected to this, that is the other layer of complexity, which is the internal organization of the work. And this question goes back again to you, Charlotte. The NIS2, we know, has some very detailed requirement, in particular concerning risk assessments and documenting security posture. How would you help clients like MedOptix, this company we are talking about, to build something that can work internally? So speaking, about different teams, legal advisor, IT, communicators, and even auditors sometimes.
I mean, a company might already have a great governance and compliance tool that can be adjusted to meet the NIS2 requirements. And if that exists, then we can support a client in tailoring that to enable, as I've just mentioned, the identification, the mapping, the tracking, the communication that is required across this compliance requirement, including the incident response piece, because that has added complexity, as Michaela has talked about. So knowing who you should report to and when, and the specifications around that. We've also created a platform with the support of the PrivacyRules team that allows both the NIS2 Directive to controls to be in there, plus, as I've mentioned, the country-specific one. So that allows everybody to see status, communicate, have audit-ready reports and demonstrable overviews that everything has been met, that everything is as it should be, or to show actually, work in progress and where things are being worked towards. And I think that's absolutely essential to manage the complexity of this, especially when cross teams, cross jurisdictions. If you think about the structure of some international companies, that this could be people who've never spoken to one another before because they haven't had to. So, you need something simple, clear, and that allows that communication and a roadmap to just be second nature and not overcomplicated.
Yeah, and I think this is particularly interesting also, and this is a side note on the real situation that we have and the service provision. The fact that you and Endre, in the Hungarian case specifically, have created and worked towards the creation of this platform in a way that is very much tailored to the requirements of the Hungarian market, which is a great starting point for any Hungarian-based company like the one of this case when dealing with other countries. And this connects me also to my question to you, Endre. One of the key points that we heard about whenever speaking about NIS2 is related to the importance of having a legal team involved in the NIS2 related activities, in particular when we speak about classifying system and shaping the risk methodology. And this is particularly true probably in cases like the one of healthcare, where, let's remind our listeners, we're speaking about a company providing the diagnostic tools that are involved. So can you delve a bit more into this and into the relevance of the legal role in a situation like this one?
Yes, sure. I think you are spot on. It is very important to classify the risk appropriately, because only if we know the security risk level for the given information system, only then we can decide about appropriate security controls. This means that if the system is misclassified, we will have either poor security controls triggering fine, or excessive controls triggering additional compliance cost. So this is why the legal interpretation could be very important. And when we are talking about security risk level of information systems, we have to jump back and go back to mapping of information systems. And we have to identify, based on business function, each information system, patient data systems like patient diagnostic tool, cloud systems, HR database, marketing database, these systems are completely different, and it is very important to determine these systems, because only based on this we can also define the scope of risk assessment. Because when we are talking about patient data or marketing data or HR data, we are talking about completely different risks. So this is why it is very, very important to build security risk methodology, which involves the correct legal rules about mapping security risk assessment and security risk classification. And here I think lawyers have a very important rule, which unfortunately is many times overlooked by businesses.
Yeah, and I would like to support what you just say in terms of role with my next question that goes then to Michaela, meaning that too often we don't speak about the risks related to contracts under those type of situations, which make the legal support even more important if it was not enough already. And in particular, in cases like these where you have also to deal with the suppliers. We didn't touch upon them a lot so far, but it's definitely one of the key problems that then you have, and that's normally when you want to have a legal together with you. So maybe Michaela, also based on your experience, can you support us understanding what we are talking about?
Yeah, of course. So one of the security measures that was or not introduced, it's nothing new, but it's part of the NIS2 compliance, is definitely to take care about the secure supply chain. And it's heavily connected to the legal work or to the contractual work, because the security measures should be mirrored in the contracts with the suppliers. What I see from my personal experience is big advantage that NIS2 brought according to the NIS1, that we are still thinking about or talking about ICT suppliers, and majority of them will be anyway subject of the NIS2 as the managed service provider or cloud computing provider or managed security services provider. So from this perspective, and based on my personal experience, the negotiation is a little bit easier, because the set of security measures that's usually introduced in the contract is already something that they have to deal with anyway. Mm-hmm. But on the other hand, there is this kind of formal view on the thing to be compliant. So this practical experience that I just shared doesn't mean that we don't have to do the contracts, or we don't have to renew the contracts. We don't have to have the cybersecurity measures in place. It's the opposite. We really should pay attention to our contracts, so they will be in accordance to the NIS2 requirements. And and then there is also the process, all the process around how to even pick up the right supplier, the supplier which is secure enough, that provides a lot of security measures that are relevant for the type of service that the supplier is providing. So this is the whole thing about the compliance with that should be that has to be taken in place.
Thank you very much, Michaela. That was extremely interesting, and an initial note probably for our listeners. We are running out of our time, but I would like to have a final and conclusive round of questions that I want to make even more practical. If the discussion of today was not enough for you to understand why you should have support from different type of experts from different countries, because you really need to have different type of knowledge. My first question, and probably we'll start again from the legal perspective with Endre. Endre, in your view, what's the one thing that companies like MedOptix should prioritize in order to move on and get prepared or comply with NIS2? Because we have been speaking about many things, but let's try to give an hint on how to move on step by step.
Well, I think, first of all, they should make a very thorough security risk assessment and mapping, because these exercises will influence the whole NIS2 implementation project, and this will influence the security risk classification. So only when this preliminary compliance work is done, they can go further with the gap analysis, NIS control implementation, and budget planning. They should also focus on concluding a contract with the auditor, because conclusion of the contract with the auditor influences the final date of audit. And luckily, the final date of audit has been extended to end of June 2026. So, and this is a very new development. So this is why it is very important to monitor everything and stay ahead of cybersecurity developments.
Thanks, Endre. And thanks a lot also for sharing about the extension of the deadline. I don't know if it's my guess, but normally when authorities provide an additional extension, then when that extension is reached, then they are pretty strict in making sure that companies were respecting the requirements. So that's an additional call for companies that fall within the Hungarian framework to move on with compliance. Michaela, probably the answer to this question is between the lines of our discussion of today, but what do you see as the thing that company normally underestimate of NIS2 that they shouldn't underestimate?
Yeah, I will add again, view from my personal experience. I met many clients. They were like, yeah, NIS2, but we have ISO 27. We don't have to really worry about. The thing is that in a matter of cybersecurity, NIS2 really doesn't bring anything new. There are still the same controls, but what is new is this kind of bunch of legal stuff that has to be added. There has to be this kind of impact analysis. There has to be the cybersecurity authority notification. Then there's some kind of providing an additional data or something. There has to be a person that will communicate with the cybersecurity authority and so on. So from my perspective, what I see like the most underestimated thing is this kind of legal part, which is going hand in hand with the NIS2, or hand in hand, or which is added to the regular cybersecurity topics, because they are really the same. If there is a company that has already ISO or other certification, more or less, there won't be anything new, or there will be, of course, some things, but this company already can think in this kind of structural thinking about the cybersecurity. But this kind of legal work can be really tough, and I believe will be very challenging, because, for example, the situation in Czech Republic is like, we are expecting that the new cybersecurity law will come into force sometimes between 1st September or 1st January 2026. And then there is only like 40 days, or right now it's 60 days to do the notification. But in case I underestimated the effort, and I don't know which kind of cybersecurity service, which are regulated, I'm providing, then it's even harder to make the right notification. And then, of course, there are the sanctions, which are quite high for non-compliance with these legal requirements, then not to really do proper MFA on every system that I have in a company.
Thank you very much, Michaela. That was extremely interesting. And I think it's very much connected to the answer to my next question, meaning that, Charlotte, I'm addressing this question to you because you are the non-legal expert. So, your perspective is different one. And probably you are normally the type of company that receive requests from the clients that maybe have not yet involved legal experts. So can you share with us, in your view, by being working, both in situation across together with other type of experts and in situation where you are contacting alone, what's the advantage of taking not just NIS2 but framework like NIS2 with joint legal and operational strategy made together with other experts, like in the case we are sharing right now?
As Endre and Michaela both said, NIS2 is not just a tech compliance issue. It spans governance, legal, and I suppose corporate accountability, as well as the resilience piece. Of course, it comes into it. The only way to deliver confidence to regulators is, I think, for legal teams and technical teams to be in sync. because one has to demonstrate to the other and to the company that compliance is there and auditable and will meet the expectations of the regulator. I think it's only when these come together that you actually get the assurance and resilience that's required, and that's the underpinning need and requirement of NIS2. Essentially, the advantage is I think you're going to save a lot of time, headache, and potentially the implications or fines that could come by not getting this right. And I think just saying, we have ISO 27001 in place, we've got some technical controls in place, we're good. I don't think that's good. It's not going to cut it. It has to be across the board. Perfect,
Charlotte. Thank you also for this contribution. And it's really important, even for us from the privacy rules perspective, meaning we can already see the advantages when we work together with you in this type of environment, because whenever there is an exchange between technical or legal experts or between legal experts updating each other, you learn that maybe in certain countries you should approach things differently, maybe because the authority has a different approach, or maybe because there is in general not just a framework which is different. I think and I thank you very much for being with us today and giving our listeners a hint and understanding on, how the members of the Alliance work together in a specific case and how they would work together under NIS2. That was a great opportunity. So thank you for your time. Thank you to our listeners for being with us today. I very much look forward to working with you all and many of the people that were listening to us today, hopefully very, very soon. So thanks a lot again, and bye everyone.